welcome everybody, and thanks very much for joining. Apologies first that we had to rearrange this from last week. Just to say that the webinar is being recorded, and we will share a copy of the recording. It'll probably be in the new year now, but we'll get that to you as soon as we can in early January. If you have any technical issues during the webinar, then please can you put those in the chat function, send a message, and we'll do our best to resolve those for you during the session. And we've got some pre-prepared questions because we asked people to submit questions beforehand. But if any questions arise as we're going through the webinar, please do put them in the Q&A box, and we will do our best to get to those questions depending on timings at the end of the session. Okay, so today we are just a very brief overview here. We're going to look at the new duty to prevent workplace sexual harassment, came in October, and just going to give you a very quick highlights tour of the main issues to be aware of. And then we're going to dive into the practical considerations as to how you go about implementing work streams to be able to implement the new duty and show that you have taken steps. When registering for this event, you had the opportunity to submit questions, and thank you to all of those who did. We've pulled those together and we've got some broad themes and questions which we will talk through as part of the practical considerations. And as I say, if there's time left at the end, then we will go to any Q&A that's arisen during the session. I'm joined today by my colleague, Joe Oliver, who's fellow partner in the employment team, and I'm going to hand over to Joe now to talk you through the main aspects of the new duty.
Thanks, Gareth. Good morning, everyone. So we're going to kick off with a bit of a summary, really, of what the new duty entails. So you're probably already aware that the duty came into force on the 26th of October this year. And the duty is to prevent sexual harassment in the workplace. So it's a positive duty to take steps to ensure that staff don't experience sexual harassment. It's around taking reasonable steps. So what's reasonable will depend on the size of your organisation, the type of sector that you work in, the type of risks that your particular business or organisation faces around harassment, and whether there has been an issue in the past, and so something that is clearly something that needs to be addressed, will all be factors as to whether it's reasonable and what is reasonable to do to prevent harassment in your particular environment. So it's a duty to take those steps, and in terms of the potential penalties if you don't, it's not a standalone right for an employee to bring a claim if you haven't taken reasonable steps to prevent sexual harassment. But obviously, if they are subjected to harassment and they bring a claim under the Equality Act that they've experienced sexual harassment in the workplace and you haven't complied with the duty, there can be quite a significant uplift on compensation that's awarded in those claims. So the uplift can go up to 25%. So if you're looking at claims where compensation's already uncapped and there are risks around claims for personal injury award and injury to feelings, you can see that adding 25% on top of that could be a significant financial penalty for an employer, and therefore it's a good deterrent and a good reason to make sure that you're complying with that duty to avoid that financial penalty. So although an employee can't take direct action for failing to comply with the duty, the Equality and Human Rights Commission can. So if a complaint was made to the Commission, then they could investigate, they could take action against your organisation, and there are issues around reputation, employee relations and other areas if you're not being proactive in fulfilling your obligations under the duty. And there was already technical guidance in place to help employers navigate how to prevent sexual harassment in the workplace and what steps and what risks to look out for. That guidance has been updated, and if you haven't had an opportunity yet to review it, it'd be really helpful to do that. It's really useful and gives lots of practical examples of behaviours and areas that you would want to consider. And the HRC has also released an 8-step guide, which is practical steps to assist you in considering what are reasonable steps to prevent harassment in the workplace and how to comply and take those steps. So it talks around auditing arrangements, looking at risk assessments, looking at training, all of the things that you would expect, but it's a really useful practical framework to follow. So again, if you haven't had a chance to look at that, it's something to put on your list for things to review in the new year. So if we move on to the next slide, please. So the positive duty that's come into force to prevent sexual harassment works alongside the existing reasonable steps defence that was already there under the Equality Act for employers who are facing claims of harassment to be able to show that they'd taken all reasonable steps to try and prevent those kind of behaviours that led to that claim as a defence in circumstances where an employee had gone to the employment tribunal. So there's a slight difference between the all reasonable steps defence and taking reasonable steps in advance. One, in the defence, you're expected to do everything that is reasonable, whereas under the duty, it's just taking steps that are reasonable. So a slight difference there to think about. But one aspect of it is that the defence is about thinking about controlling behaviour of staff so that they don't harass other members of staff and that they understand expectations that are set around appropriate behaviour in the workplace, whereas the new duty is more about controlling the experience that your staff have so that they don't feel that they are in a workplace that has a risk of harassment, where they feel that the culture is open and transparent around reporting harassment. So there's a slight nuance between having the duty to prevent being about setting that culture and that tone and what your organisation is about and how your workplace should feel to staff, and then the defence, which is about making sure that staff know what behaviours aren't acceptable, aren't tolerated, understand what harassment looks like, and are not committing acts that would put your organisation at risk. As I mentioned, the technical guidance from the Equality and Human Rights Commission talks in a lot of detail about the importance of risk assessments and action plans, and Gareth's going to talk about that in more detail. And I know that we've had some questions already submitted in advance where people are thinking about what should a risk assessment look like, what should their action plan be. And it's quite clear that if you haven't done a risk assessment or if you haven't got an action plan in place, you're not going to be in a position to say that you've complied with the current duty to take reasonable steps. Those are going to be your core reasonable steps alongside training and alongside other measures that are bespoke to your organisation. Those are the key things that you need to be thinking about. If you haven't already, you need to be thinking about them as an immediate step to be putting the right processes in place to show that you're complying with those duties. If we move on to the next slide, please. So when the new duty was being introduced and when the Act was being considered through Parliament, there was at the start provision to make third-party harassment to put protections in for third-party harassment. They're not currently in the Equality Act. So the Equality Act deals with harassment from an employer or worker to another employer or worker, but not the harassment that is experienced by a third party, so a service user or a client to one of your members of staff. And initially, third-party harassment was going to come in so that there was an extra layer of protection from staff who might be in public-facing roles and might be more exposed to that third-party harassment. But that wasn't taken forward. However, the duty to prevent harassment, sexual harassment, does require employers to be thinking about those risks. So the prevention work that you would be doing would be around ensuring that not only are the risks identified and addressed from employee to employee or worker to worker harassment, but also around ensuring that you are setting clear expectations for those who come into contact with your staff. So any contractors, any service users, any customers, any clients, that it's clear that harassment of your staff isn't tolerated and that you're identifying those risks alongside other risks within your own workforce. And so that's an important element under the new duty. And then just touching on the Employment Rights Bill. So this is a sweeping range of reforms that are coming into effect for employment law over the next few years. And one of the elements of that around harassment is that the new positive duty to prevent sexual harassment will move from being reasonable steps to all reasonable steps. So the threshold and the expectation on employers is going to be higher once the Employment Rights Bill comes into force. And also the Employment Rights Bill is going to put in place protection for staff from third-party harassment as well. So they will be able to bring claims if they're subjected to harassment in the workplace by a third party. So knowing that that's on the horizon and that's the direction of travel, all of the work that you do now to comply with the duty should be thinking about those next steps as well. So you've got a real opportunity now to think about any changes that you need to think about with your culture, thinking about the particular risks that your organisation faces, and developing your risk assessments, your action plan, so that you are future ready and future proofing, and you've got all those changes that you might be thinking of making to your culture underway by the time the extra level of protection comes into place under the Employment Rights Bill. We can move on to the next slide, please. And I'll hand over to Gareth.
Thanks, Jo. So thanks very much for a very succinct summary of the main obligations that employers now need to deal with. So the next part of the webinar is for us to just talk practically about how you go about implementing that duty and going through the various steps. And we've got a visual about being the tortoise and not the hare. And really, I suppose what we're trying to say is that there's quite a lot to do, and it can feel a little bit overwhelming as to where to start. Joe's given some hints as to that, but I think it is one of those things where organizationally you're probably going to start relatively slowly. You're going to end up building a body of work and a narrative as to how you've reviewed the various risks across the organization and then dealt with them. So I think you would be looking initially as to how you'd go about an audit, informed by your knowledge of your workplace in relation to where are the main risks in relation to employee interactions with customers or other third parties, and the types of settings you have and the gender makeup of parts of your organization. And that will then give you a sense of how you then go about building your risk assessment and identifying what's working well and what you might want to build on going forward. And I think one way to think about this is that ultimately this duty gets tested in an employment tribunal if you get to the point where you've unfortunately had a sexual harassment complaint that has gone to tribunal. And as Joe said, there will be a scrutiny of the employer as to whether reasonable steps were taken to prevent the harassment. And if not, whether there's then an uplift in relation to compensation. So one way to think about this is if you were having to speak on behalf of the organization and give a narrative of how the steps you've taken, what would you want to say? What does your witness statement look like? Because your HR lead in relation to areas, or maybe one of your executive team, are going to have to give witness statement to say, it's regrettable whatever has happened, but the organization had taken steps to prevent harassment and we complied with our duties, so to avoid an uplift. And you're therefore going to want to give a narrative around the auditing that happens, the risk assessment, and then the various steps that you have taken to build up a body of work to take those preventative steps. So just have a think about, as a starting point, what would you want your statement to say? How comfortable would you be at the moment with regard to what you'd say about your organization's approach to these issues, and where you would like it to be? and that will just start to help you with a to-do list in the new year if you're not already underway with this, in terms of then thinking through the steps. And if we go to our next slide, we try to summarize the types of things that may be on your checklist with regard to, I've mentioned looking at the doing a workplace audit and thinking about your workplace settings and how people interact with each other and where there are potential risks, which would then lead to you building a risk assessment. And once you've got a risk assessment, obviously the corollary to that is to then have an action plan to manage those risks and show how you have attempted to mitigate them. Quite often you won't be able to remove them. It is just a fact of the organization of being in business or providing the services that you provide, but you want to be able to evidence that you've thought through how you might mitigate those risks going forward. And obviously part of that will be educating your workforce, and you will have various policies in place, how they fit for purpose, and do you want to either review or amend them or update them or introduce new guidance. And this is where Joe mentioned the EHRC technical guidance. It's very helpful to read through that and just help you inform how you might want to make amendments or introduce some new policies in relation to making it very clear to the organisation that harassment is not tolerated. You then need to think through, obviously, how you're going to engage with staff to get buy-in in relation to these. There's no point just posting something on an intranet without being able to show that you have brought it to life. So think about your consultation groups. Once you have made changes or you've got proposals, should you share those with relevant consultation groups within the organization? Some organizations have women in the workplace groups as well, and think about how you'd share those to get a better understanding of whether employees have got are buying into what you're saying, or whether there's other areas that they'd want you to think about. And again, in the HRC guidance, in the longer form, the technical guidance, there's quite a good section around how, in a construction industry example, somebody went through a number of different steps, both in terms of thinking about the policies, but also consultation to get buy-in to introducing a anti-harassment policy. And it's quite a good little case study just to get to grips with the issues. As well as having your policies and engagement in place, you obviously need to think about what reporting mechanisms you have in place. And in relation to that, you're obviously going to be relying on your line managers and others in the organization to then deal with that. So this is where the structured training comes in, both in terms of everybody understanding the expectations of the organization, but also then making sure that those who may be receiving complaints or needing to act on complaints have had some training as to how they should approach those complaints. At times, a manager may want to be managing an issue away, and that may not always be appropriate when someone is complaining of sexual harassment. You may want a slightly different skill set in terms of how you get an understanding of what's happening and how you then deal with it, which then leads into, again, being comfortable that you've got processes and people in place who can help you act on complaints and deal with anything that is going to arise in the workplace. And in relation to talk about the workplace, Joe mentioned it as well, there is a need to consider third-party risks on the basis that the preventative duty relates to your employees. So obviously their experience, as Joe was talking about, means they will interact with customers or with suppliers or contractors. And if you haven't thought about that interaction and thought about any steps you might want to put in place, codes of conduct, underlying to contractors, the level of expectation that you have, thinking about your visitor experience and how you may, again, set various standards in place, then it may well be that you would be found wanting as to whether you've taken reasonable steps at that point. So do think through all the aspects of the relationship. But as I say, going back to the tortoise and the hare, it's very much a step-by-step process, and things may well happen. And it's also therefore evidencing how, when things do happen, the organization learns from those and refines what it does and thinks about additional guidance or learning or steps to be taken to deal with issues. So that's the overview in relation to how we think you should approach these issues and build your checklist and build your documents to help you with that. We've developed various templates in terms of risk assessments and checklists that we can talk to you about separately if that's a helpful thing. But the other thing we do when we set up this webinar is to get your questions. The next part of the webinar is going to look at some of the common themes that those questions raised. And Joe is going to kick us off with looking at risk assessments that we have been talking about.
Thanks, Gareth. If we could move on to the next slide. So the first set of questions, as Gareth mentioned, is around risk assessments. The questions are just popping up now. So what are the key considerations when conducting a risk assessment for preventing sexual harassment, and should these be tailored to different departments or locations? So the starting point is that your risk assessment needs to be specific to your organisation. That probably sounds like a no-brainer, but just sort of taking something off the shelf and saying, well, we've done a risk assessment isn't going to be enough to show that you've complied with the duty. So you need to be thinking about the specific vulnerabilities within your workforce and your workplace. So that's the type of environments, multi-locations could create more risk, thinking about management structure, thinking about the gender makeup of your workforce, thinking about what your existing policies say and whether they've been updated, how frequently, or if training has been offered at all, will all be part of the things that you will be looking at going through your risk assessment. So if you have a business or an organisation where there's a lot of lone working, for example, that's going to be something that's perhaps higher risk, or where staff are working directly with members of the public but don't have other colleagues with them and working in areas where they might be a bit more vulnerable. Those are things that you'd need to make sure that you are reviewing as part of your risk assessment process. And Gareth talks about this, making it a collaborative exercise. So thinking about consulting with staff to understand exactly what their concerns are around harassment, where they feel vulnerable, so that you can take their voice into consideration when you are looking at risks and looking at how those risks can be addressed. And making sure that you're properly recording the findings from that assessment. And there might be different risks that are associated with different locations. You might do different type of work at a different place. It might be a very different culture within different places. So it's making sure that your risk assessment does look at the nuances within your particular organisation. And if you're thinking about working towards changing cultures, that's across all of those locations, and that you've got champions within those locations who can promote the culture that you're trying to embed within your organisation. If we move on to the next question, how often should risk assessments be revised and updated? So it's really important that your risk assessments are dynamic documents. So risks are changing all of the time. Certainly you need to be doing a risk assessment now, but you need to be thinking about how effective the measures that you've put in place following that risk assessment are, and carrying out at least annually a review of how that risk assessment has bedded in and how change is happening. Is it working? Are you seeing either an increase in people coming forward and sharing any concerns, so that they feel that they are able to voice any worries about what's happening in the workplace? Are you seeing an increase in complaints? Are you seeing a reduction in complaints? I think it's doing that review and assessment is really important. And if your organisation is going through a period of change, so if you are restructuring, if you are merging with another organisation, if there are any significant changes, it's a good time to review your risk assessment to see whether it's still appropriate and whether any new risks have developed or other risks have already been addressed. If we go on to the next question. So what are the main risk factors organisations should consider? So I've already touched on things like lone working. That's obviously going to be a high risk area. Thinking about where there might be an imbalance of power in working relationships. That's again a high area of risk. Thinking about where you might have a lack of policy or a lack of training. that's going to be an immediate area of risk where you're potentially exposed, because staff aren't given the required guidance on what's expected of them, how to report things, how to address it, particularly line managers. If line managers haven't had training, and Gareth touched on this, the need to have training that helps them respond to an allegation if they are the first port of call for someone they line manage, that they're taking that seriously, that they are listening to what the employee has to say, and it's not a culture of trying to manage the complaint away, but understanding what's behind the complaint, what can be done to resolve it, what can be done to protect the workforce, and what can be done to change behaviours that are triggering that. So I think there's one more question. In practical terms, what does a risk assessment look like? Well, there's no set format, but we've developed a risk assessment and we've used an Excel spreadsheet that works through and takes you through step by step the sort of things that you need to be thinking about, where risks might arise, how that risk could be managed, and then who's responsible for that risk and when should that action be taken by. So you've got that accountability and you can track what needs to be done and when and who's going to do it, so that you've got an audit trail. And if you had to, as Gareth mentioned, provide a witness statement in employment tribunal proceedings, you could talk to the risk assessment that had been undertaken, you could explain who was responsible for each step along the way, when it was done, and if you've got that as solid evidence of the work you're doing, it puts you in a really good place to be able to show that you've taken reasonable steps. Some people are quite daunted by completing risk assessments, but as I say, we've got a template that does walk you through it, and we can help and support you along the way, particularly if you've identified a risk that you're not sure about how to address, then by all means get in touch with us, because we're very happy to help with that. And it's important that you've got your mitigation strategies for those risks clearly documented alongside what the risks are. Just saying that there's a risk, but not saying how you're going to address it, isn't going to help in complying with that duty. And if we move on to the next slide, please. And I'll hand back to Gareth.
Thanks, Jo. So the next questions are around what's reasonable in the context we talked about taking reasonable steps. So if we go to the first question, please. This is a question about what's reasonable under the new duty and other specific measures that all employers should take. I think it's important to keep in your mind that this is an anticipatory duty, as in it is something that you're expected to try and anticipate the risks and seek to manage them, rather than necessarily just responding to things that have happened in the workplace previously. So it's very much wanting to think about your workplace. Therefore, as Jo says, it very much depends on your particular workplace and the risks that you identify and work through, and where you anticipate there may be issues that you want to manage. It's also an objective test ultimately, so it will depend on the facts and circumstances. So it will be judged against what then happens if there is then an issue, or there's a particular area where there's a potential heightened risk of harassment taking place. And as we've said a couple of times, really, and the technical guidance underlines that a risk assessment is key. If you don't, the guidance is fairly explicit on this, if you don't do the risk assessment stage, then it's unlikely that you'll be able to say that you've complied with the obligation in relation to taking reasonable steps to prevent sexual harassment. So it really is a very good starting point to think about it, get your head around this anticipatory duty, and to think about your workplace and the workplace setting. It also should bear in mind that some things that are there may still be reasonable, even if they wouldn't have prevented a particular event. So you may well have steps that are reasonable in terms of a policy and training and guidance, and an employee still does something that amounts to harassment and is something completely outside and couldn't be anticipated. That wouldn't mean that you'd failed in your reasonable duty, you'd still followed your reasonable anticipated steps and what you should be doing. And there may always be cases that then challenge that in terms of whether there's then further learning and things to think about. I think there's a second question with regard to reasonable steps, and that's in relation to the balance between taking steps and respecting privacy, and particularly in relation to anonymous complaints. There's a little bit of this in the technical guidance, and I think it's also fairly well travelled in relation to generally how you want to manage issues relating to someone who wants to remain anonymous or doesn't want their details sharing. The practical issues are very much the same. You need to make sure that you understand the complaint that's being made, and preferably you'd want somebody to still sign off on that complaint so you understand what is being said and who is saying it. Once you have that, and if they want to then remain anonymous, obviously you can talk to them about why that's the case and whether they've got any particular concerns around privacy, or whether they think it's going to be detrimental for them to be seen to be complaining, and whether there are ways of managing that. Obviously, we have victimization laws, and you'll be familiar with your policies that talk about the fact that you would want to give support to an individual and would not tolerate someone being victimized for having raised an issue or made a complaint in the first place. And so just you need to think through those steps. Ultimately, if someone is not comfortable or reassured that they are going to put their name to the complaint, then the other half of that is to also then think through the steps you would take to address it. If you can't specifically address the complaint with the individual, on the basis that if you started going into the events that are the concern, it would very quickly become clear who it is. You might have to think of a slightly wider approach to things in terms of whether there is further additional training, whether there are further wider discussions that need to take place, and an underlining generally or in particular workplace settings as to what the expected standards of behaviour are. So you're going to have to think a little bit more laterally as to how do you get your message across and how do you show you've sought to manage that risk, notwithstanding that somebody doesn't want you to directly investigate a complaint in relation to it. And obviously, as part of that, there's a judgment call, and you need to think through whether you respect that request to be anonymous and you give further general guidance and maybe have enhanced listening techniques in place and feedback loops, and think about pulse surveys and other ways of trying to get some feedback to see whether there's an issue, or whether you think this is so serious and going to have to explain that to the individuals raising concerns and then still take action in relation to the concerns that have been raised. So it's going to be, again, depending on facts and circumstances, but it's absolutely the case that you need to tread carefully when you have someone who wants their privacy respecting or doesn't want it to be dealt with as a named complaint, because it may limit ultimately what you can do in terms of trying to resolve the issue. I think if we move on to the next question, this is one where Joe's going to look at the training requirements.
Thanks, Gareth. So what are the best practices for training employees and managers to prevent sexual harassment, and should training be mandatory? So in terms of best practice for training, with any kind of training, it's always important that it's specific to your organisation, that it's bespoke, that will help it resonate with your employees. Training that's interactive, that's engaging, that provides real life examples that actually are the things that your staff are experiencing or might see within their workplace, I think is a really useful way of making training something that is really absorbed by members of staff. All staff, if you're going to show that you've taken reasonable steps, should have training. Is it mandatory? The duty doesn't say you must train staff, but it's quite clear that a reasonable step in making sure that harassment is not an issue in your workplace is training staff. So whilst it's not technically mandatory, I think failing to do it would put you at risk. So within each of your organisations, making that training mandatory for your staff is a sensible way forward. Thinking about having a different level of training for managers, because they will need to set the tone in terms of making sure that staff understand their obligations, making sure that anyone who has been subjected to harassment or has seen harassment happen feels confident and comfortable to come to them. So training that empowers them to be able to deal with those difficult conversations, to be able to take the step back and listen objectively to what they're saying, to set aside any biases around the people who might be involved in the complaint, and to be able to take the right first steps. In really serious situations of harassment, that might even involve letting the member of staff know that they can make a complaint to the police, understanding the process within your organisation for reporting it, what that looks like, how things will be investigated, and being able to share information in that way with a member of staff and make them feel that they are not being dismissed or that their concerns aren't being taken seriously, I think is a really important step, both in terms of complying with your duty and just generally culture within an organisation. And making sure that training covers not only what the expectation is around behaviour, but how to report, who to report to, what your organisation does to support people in circumstances of harassment, or if you're someone who has had a complaint made against you, how are those people supported? So including all of that in your training and making sure that there's an awareness as well that staff who are bystanders, who haven't necessarily experienced the behaviours firsthand, still know that there's a level of responsibility collectively, that if you see something, that you should be reporting it so that the employer can then take steps to deal with it. And that's, I think, a really important thing, both in terms of culture and compliance with the duty, that within the organisation, you don't want to have a situation where everyone knew something was happening, but no one took any action. And encouraging that bystander intervention, I think, is really important. Can we move on to the next question? So how can organisations effectively track and evidence that training has taken place? So keeping a training log, sign-in sheets, or using online tracking if you're using an online training tool, making sure that you're not just recording who attended and when, but making sure that you're recording what was taught at that training session. We see it quite often in employment tribunal situations when we're trying to say, yes, we have complied with our duty, we have taken all reasonable steps to prevent harassment, this person had training and they knew what was expected of them, and there will be a cross-examination question to say, well, what does that training entail? So if you've got a record of what was taught at that session, who was there, you're able to show that extra piece of the puzzle, that what was specifically involved in that session. And online training can be really helpful as well as a way of getting to a large workforce and providing regular updates. It's important that training isn't just a one-off. It's really clear that it should be at least annually. It may be that when someone's promoted into a managerial role, it's part of their appraisal and part of their performance management that they have undergone training to be able to deal effectively with these issues. Also thinking about investigation training for staff who might be tasked with the responsibility of investigating a harassment complaint. Carrying out a really clear investigation, making sure that it's well thought through, that the findings are reasoned, that the right people are interviewed, that there's no bias involved in how the evidence is collected or reported. That can be really helpful as well. So thinking about that as part of the training requirements and your broader training requirements when you're looking at harassment or any discrimination issues is really useful. And if we can move on to the next question, for a small business of 20, what is the best method of training? Probably if you've got 20 staff, you could do training in person, and in-person training is always more engaging in my view, and can be more interactive, gives people an opportunity to start debating the issues as well. Also, it can give staff an opportunity to come forward and say, oh, I saw that, I didn't realise that was harassment, but did you know about this? So I think it gets a dialogue going to have people together collectively talking about these issues. And we do regularly run training sessions, and our colleagues at Narrowkey HR deliver sessions for different organisations that can be tailored specifically to them. So I'd say in-person training if you're a small business, but equally e-learning again is very helpful, easy to track, and can be quite useful if you've got a workforce of remote workers or people who are doing different shifts and it's hard to coordinate getting everyone together in one place. So sometimes doing a combination of the two, but certainly I think while you're embedding this new duty and you're taking all these steps at the moment, trying to do some in-person training would be a really good idea. I hand back to Gareth.
Thanks, Joe. And the final set of questions we have this morning are just going to look at offsite and social events and the extent to which the prevent duty extends into those settings as well. And the question is, what obligations do employers have in relation to offsite working, client interactions, or social events under the new duty? And essentially, the answer is that the new duty requires employers to look at taking reasonable steps to prevent sexual harassment in all work-related contexts. So that does include off-site working. It would include whether a client interactions either on-site or off-site, and social events that are essentially formal ones that are organised by the employer, whether that's team building or an office party, those areas. So in relation to all of those types of settings, you need to think about what the risks are that may arise in terms of therefore what level of briefing or codes of conduct or extension of your policies you might want to put in place so that they extend beyond the the internal workplace, maybe policies that are in a handbook are maybe shared with third-party suppliers, asking people to confirm that they, whilst interacting with you, will observe those minimum standards, those types of things to show that you've thought about making it very clear what is expected in other workplace settings. And obviously the key is to think about where it is that essentially the workplace, it's still very much connected to a workplace setting in relation to the activity. So it sometimes surprises employers that social events are caught by the harassment duty. And I think it very much is just thinking through, is this something that is initiated through work? So is it organized through work? Is it a work hosted party? We're all in Christmas party season, and absolutely the duty would apply to have thought through, are there any enhanced risks in hosting a social event for employees, and whether anything can be done to mitigate those risks. And maybe a very simple example is if you've identified that there's going to be alcohol at an event, it's a party, people may be slightly more informal in terms of enjoying a party, whether as part of the invitation or confirmation of the evening, you just include a reminder that it is a workplace event and there are certain standards of conduct that are expected, without wishing to be a party pooper in terms of approach. But there's just ways of gently reinforcing what's required. Some organisations go further and they maybe have party chaperones or people who are specifically being tasked with making sure that they're helping support the event and are available if there are difficulties. I think we've got a second question, which then takes that a little bit further with regard to what are employers' responsibilities when employees engage in informal social activities connected to work. And again, if it's a workplace thing that's been organised, then generally what we've said so far would apply. But obviously, if employees have friendships outside of work and they're still socialising together, then the duty doesn't necessarily extend for you to anticipate the risks from that. But the duty to prevent probably would extend to if you then found that there was a complaint or a concern about a colleague's behaviour, that essentially therefore brings it back into the workplace. And the technical guidance is clear that it would look for the employer to investigate the concerns if they're then being raised back in the workplace that have arisen as a result of the informal social activities. So if there are complaints, you would be expected to to investigate those and to deal with the workplace issues that maybe arise from those interactions, or whether something adjacent to the workplace that's happened, and whether therefore you manage part of the issue, or tangentially look at how you might manage the risks that arise from that. Okay, that's the coming to the end of our formal um, question and answer. I'm just going to hand over to Joe to formally close this part of the event, and then we can see whether there's any Q&A that we would want to talk through now.
Thanks, Gareth. Before you leave us, we've got a poll, and if you'd like to complete it, it's asking whether you'd like any further information from us about support with addressing the duty. So whether you'd like information around staff or manager e-learning or training, whether you would like help or support with in-person training, or looking a bit more widely about the culture of your organisation. Now's a good time to be thinking about, are there needs to change culture? What do we want to achieve? What is our people strategy, and how does dealing with issues around discrimination and harassment sit within there? So if you'd like some support, or if you're interested in any information, do complete the poll and we can get in touch with you. I think that looks like everybody has completed it. So thank you very much for doing that. And that brings the end of the session. Save for any questions. So I don't know, Gareth, if you've had a chance to have a look in the Q&A box to see if we've had any questions in.
I've just taken a peek, and it looks like we have answered all the immediate questions. We haven't prompted a further question in the Q&A. So from that point of view, hopefully we've answered everyone's questions today. It's a busy time of running up to Christmas, and of course it may well be that this has gone on the to-do list for January. So again, if we can help in the new year as these things get picked up, then we would be happy to do that. But I can't see any further questions from today, so I think we can bring the webinar to a close. Thanks very much for everybody who joined us this morning.